to kick things off, would you please be able to give us an overview of your career to date?
Thank you, Jemima, and thank you for inviting me to come on to this second episode of Conversations. So I didn't take the usual direct path to the law. I spent my first few years after high school living in Japan, working at the Australian Embassy over there. Sorry, I think we've just got one person with their microphone on causing a bit of a feedback. I'll continue, but let me know if it's still got more feedback. So I was living in Japan for a number of years, working at the Australian Embassy, studying to get my top-level proficiency in the Japanese language. While I was over there, working with a lot of diplomats with law degrees, I decided that I wanted to do law myself. So I moved back to Australia and did my law degree at Sydney University. I was a paralegal at Clayton Utz for the entire time that I was doing my law degree. And then I went on and did my summer clerkship and grad program and a number of years at Baker McKenzie in Sydney. Then in 2016, I decided to move up to Queensland to be closer to my family and took a role as a senior associate at a national firm, McCullough Robertson. And then in 2021, I decided to establish Williams Arbitration as an independent practitioner. Throughout that time, or since 2021, I've been kept very busy with tribunal secretary work and arbitrator work, and I've also done some counsel work as consultant to firms who needed some extra help with their arbitration matters.
Fantastic. And I'm sure those language skills have definitely come in handy. And I'll also mention that Erica is on the Nominations Commission for ICC Australia.
Yes.
So today we're going to be speaking on the topic of non-participating respondents. So situations where a respondent stops participating either during the whole arbitration, they never take part, or at some point during it, they drop out, which is quite a challenging situation for a number of reasons. You are a great person to talk to about this because you've written an article on this subject called "The Non-Responsive Respondent, Taking an Arbitration Forward and How," and that was published in Arbitration, the International Journal of Arbitration, Mediation and Dispute Management in 2019. So the first thing that springs to mind, for me at least, when it becomes apparent that a respondent is no longer taking part is due process. So be great to hear what due process issues should the tribunal and council be aware of, and how would you suggest they address this?
Yes, thank you, Jemima. I think everyone is well aware of the model law requirement to provide each party to have a full opportunity to present their case, which it's widely understood that a full opportunity is a reasonable opportunity. In fact, in Australia, that's in the International Arbitration Act, the language of full opportunity to present one's case is amended to say reasonable opportunity to present their case. And this is also reinforced by, for example, I think it's Article 42 of the ICC rules, which requires arbitrators to act in the spirit of the rules and make every effort to ensure that the award is enforceable. And this then corresponds with the New York Convention and a requirement, and one of the grounds on which an award might not be enforced is if a party was not given proper notice of the arbitration or was unable to present their case. So all those model laws, rules, legislation, and New York Convention interact to give arbitrators quite good direction in that they really need to ensure that a party is given a reasonable opportunity to present their case. And there was a recent case, when I say recent, 2021 case in Australia where a party to a CTAC arbitration was able to successfully challenged the enforcement of an award on the basis that she was not given proper notice of the arbitration. And this was a case where they served the notice on, there were 4 respondents. The only respondent challenging enforcement was the second respondent, and she was the wife of the first respondent, who was the director of the third and fourth respondent companies. So she was the only one participating in the challenge to the enforcement proceedings. And what had happened was the notice of arbitration was delivered to an address in China, which was not her address in the notices provision of the contract. So she was able to argue that it was not an address she had provided, and it was not an address she had agreed to for notices. And to go one step further, the judge in that case said that he could not infer through the spousal relationship that she had been given notice of the arbitration. So she was able to successfully challenge the enforcement of that award.
Oh, wow, there you go. And I know we had a situation recently with a non-participating respondent where we were trying to deliver hard copies to their office, but it seemed they were no longer there. And so we had a couple of other addresses, but it was definitely a balance between confidentiality concerns and then trying to make best efforts with the information we had. So yeah, it can definitely be a balancing exercise.
That's right.
Would you have any advice for counsel for the claimant on what they can do to help with these due process concerns?
Yes, of course. It's of course in the claimant's best interest to also try and ensure that the award that's delivered at the end of the process is enforceable. Otherwise, what's the point of going through the whole process? So what you've identified is when you, in your non-responding participant case, they seem to not be at the address anymore. But what I would encourage is, even if the contract provides for service to an email address or the rules, many of the most recent versions of institutional rules now provide for arbitration by notice by electronic means. But if you're not getting any response from that, it makes absolute sense to effect what in litigation proceedings we call personal service. So actually walking to the front door of the office, as you've experienced, and handing it to someone. So in a case where I had, thankfully they were at the office location, and the assistant to the director of the company would sign each time, whether it was a letter from the arbitrator, whether it was a pleading, any piece of correspondence was sent both by email and by printing. The counsel for the claimant had to print it, deliver it, get the signature from the office staff, and then deliver an affidavit of service. So, and I mean, yes, it's time consuming and contributes to cost, but the implication of not going that extra mile to ensure that they are aware of every step of the proceeding could be quite significant. So that's probably what the claimant's counsel needs to do their best to ensure that the non-participating party is aware of every step of the proceeding along the way.
Yeah, we had a very lucky trainee.
Oh, you just froze for a moment.
Am I back?
Yes.
Okay. One thing we also found as counsel for the claimant was kind of gently reminding the arbitrator at times that everything needed to be in writing. He gave some oral directions at the end of the hearing, and although it was in the transcript, which was circulated, we felt maybe that wasn't enough. So asked him to issue them in writing.
Yeah, and that's the other thing. An arbitrator shouldn't have any ex parte communications with the participating party where at all possible to avoid that.
And what advice would you give, apart from that, to the tribunal? Any practical tips?
Yes, well, as I emphasised at the beginning, it's crucial for the arbitral process to ensure that the respondents are afforded the opportunity to present their case, but that doesn't mean the whole process has to stop if they're not taking those opportunities. It's a balance between providing the claimant with an efficient, cost-effective, where possible, process to achieve the award. The biggest tip I could say, and this is referenced heavily in the article that I wrote, was the Chartered Institute has published a best practice guideline for arbitrators faced with parties not participating. As we've said, most importantly, ensure that as the arbitrator, ensure that you're satisfied that the parties are duly notified of the proceedings. So I've given the recent case example in the Victorian Supreme Court. In a case that I had last year, originally the party wasn't responding, so service was effected. So the respondent wasn't represented, firstly. So the notice was going directly to their commercial email address. They weren't responding, so I directed the claimant to, as we've discussed, print every correspondence that we've had, even though it was all copied to the respondent, and have it sent by registered post. The reason it was registered post was the particular institutional rules that we were operating under provided for that as a reasonable method of delivery. Fortunately, after a couple of weeks of silence, the respondent in that case did reply to my email. So I was very confident then that I could move forward knowing that they had notice of the arbitral process and they participated. I did have to give them some extensions from time to time for them to participate, but I thought, an extension of a couple of weeks was obviously affording them a reasonable opportunity to present their case. Actually, one other thing I did in that case was include a notice, and this is in the Chartered Institute guidelines. It's a notice to the non-participating party urging them to participate, asking them to provide reasons why they won't be participating, and letting them know that their legal rights will be affected because the matter will proceed regardless of their non-participation. So it's important that participants, especially in my case where the respondent wasn't represented, were informed that just because they don't participate doesn't mean it will go away.
Yeah.
So, one other really good tip in the Chartered Institute guideline was an arbitrator faced with a non-participating participant should consider jurisdiction, even if any of the active parties haven't raised it, because if the award does go to an enforcement proceeding, it will give the judge some reassurance if the issue of jurisdiction has been considered in the award. Oh, and my last little really practical note for arbitrators, and sometimes this is a bit of a gripe from people who receive lengthy awards where the procedural part of the award is half of it, and the substantive is only the other half. In cases with non-participating respondents, it is so important to set out the procedure followed and the lengths to which the arbitrator went to ensure that the non-participating party was kept informed of every step of the proceeding along the way. So in the case I had where there was an affidavit of service for every time a piece of correspondence was delivered, we listed quite a number of affidavits of service.
Well, quite a job for your tribunal secretary, I imagine.
Yes, indeed.
Okay, that's some good advice for tribunals or budding tribunals to bear into mind. One thing that you talk about in your article is that the approach to non-participating respondents in arbitration is very different to how it would be approached in litigation, where you have processes like default judgments available. Have you had experience either with parties when you're sitting as an arbitrator or with clients when you're acting as counsel who perhaps had expectations of a litigation style process? And if so, how did you manage this?
Yes, I have. When I was counsel, I have had to explain to a client that there's no quick process in arbitration. The claimant still has to prove their case and still has to go to the time and expense of putting on evidence. In Australia, in most jurisdictions, you can file your claim, and as long as you've demonstrated that service was validly effected and there's no response after 28 days, you can move on and apply for default judgment. You just need to satisfy the court that the debt you're entitled to the debt claimed. Whereas in arbitration, where I've had a non-responding respondent, we still had the claimant, still had to put on witness statements, and they had to go to this was for unpaid invoices. They went to the extent of getting an expert accountant to go through the invoices and all the accounting records to demonstrate that everything was satisfied. So the arbitrator, I was tribunal secretary in that case, the arbitrator couldn't just rubber stamp it like a default judgment. We still had to go through the motions of hearing the parties, getting the expert evidence. That also gave the arbitrator the opportunity to question the claimant. One other important thing to note is in arbitration, if a respondent isn't participating, that doesn't allow an arbitrator to have give an adverse inference or just accept that the allegations made by the claimant are correct.
Yeah. One, we certainly had to keep our client comfortable on the costs point of the hard copies and the notaries, and that was a kind of ongoing conversation. But luckily, in a way, they ended up being parallel litigation proceedings, and it was evidence of all our efforts were really taken into account by the judge. So
good. Actually, you raise a good point on costs, because especially if you're doing an arbitration under institutional rules, there's administrative fees that you have to pay to an institution, and some of them are not small. And if a respondent isn't participating, they're probably not going to pay their share of the institutional fee. So most rules probably would provide that if the respondent, or if one party hasn't paid their share of any fee or deposits for the arbitral tribunal by a particular period of time, say within 30 days, then it's open to another party to pay that share, and they can claim that. I know under the Australian Centre for International Commercial Arbitration rules, they can claim that cost immediately and get a separate cost award. Whether they can recover the money immediately is another question. But also at the end of the proceedings, they can seek a cost award to recover all or their portion of those costs.
That's, I think, definitely what conversations have very early days with the client as soon as respondent seems to be checking out. Well, that was everything that I wanted to ask you. So we'll open the floor in case anyone on the line has any queries. Okay, Emily's put a question in the chat. You mentioned that claimant still has to prove their case even when respondent's not appearing. How does an arbitrator go about satisfying themselves of claimant's case without going so far as to assist the non-appearing respondent?
Yes, good question. It's not the arbitrator's role to step in and act on behalf of the respondent. So it is a delicate line. Arbitrators can be inquisitorial because it's a flexible process. It's they don't have to follow the typical common law practice of waiting for everything to be put before them. So how do they go about satisfying themselves of the claimant's case? I suppose if you have witness statements, the arbitrator can ask questions of the witness, but I don't think the arbitrator should go so far as trying to put the respondent's case forward, if if that helps. Happy to discuss further offline, Emily.
Yeah, it's an interesting one. I know we almost, as counsel for claimant, made an effort to almost raise counter arguments and address them.
Yeah.
To cover that base. Yeah.
Yes, I suppose that's more of a role for the claimant. And it doesn't mean to say that the arbitrator can't say to the claimant, you know, what is your position on a particular legal issue? The arbitrator can certainly ask that. But I think you're right, Jemima, that if the claimant's counsel could certainly assist the tribunal by looking at all the issues that arise and trying to address them when they aren't being put to them by the respondent. I think we lost Jemima again.
Mm-hmm. Okay, and we have a question from Hema Lawrence. How does one deal with a non-responsive party who appears much later in the proceedings?
Yes. Again, I think if a respondent appears later in the proceeding, you have to give them the opportunity to be heard. And it would be a matter of holding a procedural conference and trying to step out some directions that allow that party who's popped up to participate, because you can't just not give them the opportunity to participate.
Yeah. And I imagine claimants will be requesting some pretty hefty cost orders at that juncture. So yeah, maybe that's how you sort of even it up a little bit.
Yeah, I mean, it's better to have a non-responding party pop up later in the proceeding than have them pop up at the beginning and then stop participating, because that's really hard to gauge how much opportunity you give them to respond. So every time, one really important thing is every time you ask a non-participating participant to do something, you have to give them a time limit. Otherwise you leave it open-ended and you have no indicator for when a step has not been complied with. So that's a really important thing, is to impose time limits on everything.
Yeah. Yeah. Okay. Well, in the last 5 minutes, oh no, do we have some more questions? Yes. And Ryan, what options might be open to respondent if claimant stops participating?
Thank you. I wished I had my Akika rules. I've got them in the room, but it depends if it's ad hoc or institutional. I know the Akika rules provide for what an arbitrator can do if the claimant stops participating. I just don't have them in front of me right now, but it does allow similarly, the arbitrator can continue with the process all the time, ensuring that whether it's now the non-participating claimant is aware of every step that's happening.
Be an interesting one to manage, I think. Okay, well, with our 5 minutes left, we might finish with more personal questions to get to know you a bit better, which is, what is your most memorable case that springs to mind?
I didn't want to narrow it down to one memorable case. What I reflected on this, and I thought, as disputes lawyers, we are really fortunate that we get to learn about, in great detail, about such a variety of topics. I've had cases involving high fashion, which was super fun for me. I've had cases involving the launch of a space shuttle, which caused much opportunity for fantastic puns around the office because it was rocket science. But another highlight of a lot of cases that I've been involved with are the site visits. So the opportunities to go to things like a giant freezer. And when I'm talking giant freezer, it's stored all of the products like frozen pizza and ice cream to go out to Coles and Woolworths, and it was minus 28 degrees, and I was in a suit and stockings. Didn't really suit the environment. What else? I've walked inside a wind turbine on a wind farm, which was pretty cool, and climbed around, up and around all over a coal ship loader, amongst other less interesting site visits, but those were pretty cool.
That sounds really fun. Some niche knowledge for pub quiz, certainly. As I'm sure all of us have collected over the years. All right. Well, we might leave it there. Thank you so much for your time today. We really appreciate it. And thanks everyone for your questions and for joining. Keep your eyes out for the next episode, which will be, I think, in about a month's time. And see you all around soon.
Thanks so much for having me, Jemima, and thanks everyone for joining.